Good evening, everybody. This is Jonathan Ginsberg. I hope you are all doing well, staying cool in this very, very hot summer. Tonight on the live stream, I've got a very special guest, Spencer Bishins. Spencer is a former Social Security decision writer, and he worked at Social Security for a number of years. We've done an interview before on my podcast, but I thought I would bring him back. He's written a book about what he observed at Social Security. So Spencer, welcome. Thank you for your time. I really appreciate it.
Yeah, thanks for having me back.
Absolutely. And we've got Spencer is nice enough to made a couple of copies of his book available, and we're going to give those away during the course of this. So stay tuned. It's available on Amazon, but I'm going to give you some codes, or I think it's an audio. You've got the audio.
Yeah, it's available in paperback, ebook,
Okay.
and audiobook. We're going to be giving away the audiobook.
Cool. Okay. All right. Well, let's just start. We got some questions before we get to that. Let's let everybody know a little bit more about you. Kind of give me a little bit of a background, when you worked for Social Security, what you did, and just sort of how your tenure there, what it all involved.
Sure. Yeah. In total, I was at the Social Security Administration for 11 years. For the first 4 years, I was actually at the Appeals Council in Falls Church, Virginia. I'm sure that's an address you know very well from your decisions. And I reviewed decisions that were written by decision writers and signed by administrative law judges. The decision would come in favorable, partially favorable, or unfavorable. And the attorneys at the Appeals Council review it. They decide if it seems right or not right, if there needs to be a new hearing, whatever the decision is. The administrative appeals judges sign off on that. And then either the person gets paid or not paid, or it gets remanded for a new hearing. So I did that for 4 years at the Appeals.
Were these, just before I let you go on,
yeah.
Were these cases where the Appeals Council reviewed on their own, or were these
both
cases that were appealed by an attorney?
Yeah, I did both. I did cases that were favorable or partially favorable, and the Appeals Council took them on their own motion. And those were randomly selected so that no one was being specifically targeted. And then we also reviewed cases that were claimant appealed, either unfavorable or sometimes partially favorable, where the claimant was appealing and asking for some kind of change in the decision, presumably asking for more benefits, right? For it to be fully favorable.
Right.
So I did that for 4 years. And then I moved to a hearing office. And at that point, I became a decision writer, attorney advisor, but we're colloquially referred to at that point as decision writers. The person goes to the hearing office, which could be done by phone or on a video conference or physically, personally to the hearing office back then, would have their hearing with the administrative law judge. And then the administrative law judge gives the decision writing staff a set of instructions. I want this case to be favorable, partially favorable, or unfavorable. Here are the impairments. Here's the RFC. Here's the onset date, all that. And the attorney advisors, who are the staff attorneys, they write the actual decisions. I did that for 7 years.
Okay. And I realize that it's every place is a little bit different. I know that I had a former employee of mine who went to work for Social Security, and he said that he was in like an office building in Maryland or something, sitting in a cubicle doing decisions. So is it where some decision writers are actually in actual offices, whereas others are sort of in remote locations? Is that how they
So I was in the Pacific Northwest, and when I was at the Appeals Council, we all had cubicles. Office space in the Washington, D.C., Arlington, Falls Church areas, but at that time was very expensive. This was before the pandemic. So we had cubicles. When I moved to the hearing office, we were somewhat of a small office in an office building with a couple other non-government companies that shared the building with us. And I had my own office at that point. So I went from the Appeals Council to the hearing office, but I upgraded from a cubicle to a window office.
A real office.
So that was good. But also, the attorney advisors get a lot of telework, which kind of makes sense, right? Because it's a job that you don't really physically need to go in an office for, except for training and meetings. you can listen to a hearing and review evidence and write decisions from home. So I also, even though I had an office, I had the ability to do lots of telework even before the pandemic.
Okay. And we're going to delve a little more into what you did, but I want to go ahead and start answering some questions.
Sure.
And just feel free to jump in. I'm going to just try to answer as I can. You jump in. Justin Yu tells me that he's got a hearing in 30 days. When does a judge start reviewing his case? And I will tell you, my experience is I've had judges tell me it may be the weekend before. Usually they're so busy that they don't have a lot of time. And most of the judges I appear before, when they talk about it, sometimes we'll chat before or after the hearing. They're telling me it's a week, weekend or a couple of days before. What was your experience on that?
So I remember, I'll classify 3 different types of judges. The first type we'll say reviews it the furthest before. Some judges, what they would do they would do a week of hearings and then the week with no hearings. So they might have like 20 hearings, but then the next week, no hearings. During that no hearing week, that gives them the time to write the decisions from the previous week, but also to review for the following week and prepare. So some judges would review the previous week. The second type of judge is the day before judge. I'll do my hearings in the morning, and then in the afternoon, I'll prepare for tomorrow's hearings by looking at the record. And the third type, the morning of. My hearings at 11 a.m., at 10 o'clock, I'll jump in the record and give myself 50 minutes to look at all the evidence in your case, take a bathroom break, and bring you in for the hearing.
Yeah. Wow. Because I will tell you that, from my perspective as an attorney doing hearings, to really prepare a case properly, and this is including using AI tools now, but with or without AI tools, it's, you got to put 4, 5, 6 hours into really reviewing a record. And I just don't know how a judge or anybody could really review a record in 30 minutes and have any idea what's going on.
Well, if you just look at the amount of time, I don't know what their metrics are right now, but they were expected not too long ago to be doing 500 cases a year, 50 to 60 a month. If you have 20 work days in a month, you're expected to move through 3 per day. So that means you're spending, let's call it 3 hours per case, reviewing for the hearing, holding the hearing, writing the instructions, and editing and signing the decision. That's about 3 hours total. They just don't have 5 to 6 hours per case because of the amount of cases that they're told they have to process in a year.
Wow. And when they issued it, was it a checklist they would give you? Was it like a handwritten note? What form did it come when it went to you as a decision writer?
Yeah, that's a great question. There were a couple of different ones. Some judges would develop their own form, and then they could just check for a light, check for 20 hours, check for 10 hours, check for how much weight the person could lift and all that. Other judges would write it in narrative form, and that helps you understand their thinking a little bit more, right? Because it's more like they're talking to you. And then some judges would use kind of a combination where they check a bunch of boxes, but then they say, I'm focusing on this, but I also noticed this. And I realized this doctor maybe said something that's not consistent. Here's why I'm going to give that less weight. So it's kind of a combination. Each judge had a system that worked best for their own efficiency.
All right. And before we get to more questions, I got to ask this. How important was the testimony of the claimant in a hearing as opposed to the medical record?
I'll be honest with you here. For paying the case, not that important. Where the judges really use the testimony is to deny a case. They're looking for what you're going to say that they can use against you in the decision, not so much for you. And the reason is, from my experience, the judges who wanted to pay the case, it was mostly based on what the doctors would say. If it's a physical impairment on objective testing, if it's psychological or mental health, still on testing, but on the opinions of your psychologist or psychiatrist. But if they're looking to deny your case, they're looking for, are you telling me you do activities that involve standing or walking? Do you like to garden? Do you like to jog? Do you go to the gym? What are you saying in the hearing that I can grab onto and say in the decision, oh, in the hearing, the claimant testified he does this. That's more consistent with the state agency doctor saying he can do light work.
Got it. And that's why, by the way, folks, when we talk about this a lot in the live stream, and I certainly talk to my clients about it, you've got to be very, very careful about answering questions. Don't ramble. Don't volunteer something. If they don't ask you about it, don't offer it. If a judge asks you how long you can stand, it's 10 minutes. Don't explain, how you hurt your foot back in high school. I mean, people tend to just want to give an explanation, and I get that, but you have to just answer the question. And really what Spencer's saying is that, sometimes the more you talk, the worse it gets. You want to just really be very, very limited as far as what you say and just answer the question that's being asked.
And a lot of people, they really want to show the judge they're trying. They're
Yeah.
being honest. I'm honest judge. I'm a hard worker. I try my best. I've tried to work. I can stand, judge. And like you just said, sometimes you can share a little bit too much.
Right.
And if that's a judge who's already looked at the evidence, who's already thinking, I think this is a case I'm leaning more towards a denial, then they're not necessarily an open book, as to say. They're not necessarily listening to everything that you're saying with an open mind. They're listening for specific things that you're saying that will reaffirm what they're already thinking before the hearing even begins.
Got it. All right. So Justin, to answer your question, it depends. When the judge, it depends on what judge you have. Some judges are going to look at it, several days ahead of time, some maybe the morning of the hearing. We just don't know. Again, you've got to be prepared, and your attorney needs to be prepared to present a case, a very, very clear case. And Spencer's going to talk about this later, but connect the dots. But my point is that I think, and from what Spencer has told me really offline, and even just now, that judges don't have a lot of time. So, they're going to depend to some degree on, what your attorney does in preparation and what you say to really connect those dots. So you want to really prepare appropriately ahead of time.
That's right. You may be the third or fourth or fifth hearing they've had that day and the 20th person that week.
Right.
They're not necessarily going to remember you even 3 days later, which is why they don't start reviewing too far in advance. They just don't have the time.
Okay. Sandra says, if you get approved and eventually turn 62, do they make you take reduced, or they wait until you're 67 to flip you to regular? How do they calculate? The answer is they flip you to regular. If you're on disability, when you hit full retirement age, it'll basically be the same amount. And there's some offsets for Medicare and different things like that. But bottom line is that it'll be essentially full retirement benefit is roughly equal to your disability benefits. So they won't make you take early retirement. You will get your full benefit, basically.
Can I just add one thing to that?
Absolutely.
What I noticed when I was at the agency, though, is some people will choose to stop working at 62 or 63, retire, take the reduced amount, and also file a Social Security disability claim as a way of not really gaming the system, but using the law that exists to their advantage, saying, hey, I'm 62, I'm no spring chicken, I've got medical impairments, I've got lots of documentation, I can't work full time anymore. And so if the law supports me being found disabled, I get the full amount at 62, and I don't have to wait till 66 or 67.
Yeah, exactly. And basically what that means is that, if you win, you'll get the difference between early and full.
Right.
The practical issue, though, is from my perspective, if let's say that amount is $300 a month, I may not take that case because it's not, the amount of, I get paid a percentage of past due benefits. 25% of $300 a month times, let's say 12 months or 15 months is not a lot of money. So you may find it more difficult to get an attorney if you take early retirement and also file for disability. I do a lot of those cases regardless.
Yeah.
I do look at the amounts because, again, if it's only a couple $100 a month, I figured out how, what on the time frame, it's, let's say 18 months times, $200 is not a whole lot of money, 25% of that. So, I may be less inclined to want to take those cases. So just,
and honestly, the reason people do that, it's not even so much for that small difference. For Medicare, right? If you retire from your job and that's where you got your health care and you want to stop working at 62, or you have to stop working at 62, right? Maybe you have no choice because of your impairments. It's not optional. You want to try and get Medicare coverage before you turn 65. That's, and again, it's not gaming the system. It's not cheating. That's how the law is designed.
Absolutely. Absolutely. All right, Jen. Jen is my paralegal senior paralegal in Nebraska. Jen, good to see you here. We chatted today, as we do most days. Loki, hello, Jen. Okay, absolutely. We have a lot of our clients will tune in here as well. Blue Z. After approval, they sent me the health insurance card for prescriptions. I have to stick with that. Are there other choices? Honestly, I don't really deal that much with the Medicare and the insurance side of things. There are people out there that do that. I mean, I don't. Do you know much about that, or is that?
No,
Yeah,
it's a good time to
yeah.
remind people that if you are approved for SSDI Title II benefits, you can get Medicare coverage, but there's a pretty extensive waiting period.
It's like 2 years from date of first payment. So now
Yeah,
you after the
so
waiting period. So it's a
right. So you
long.
might need to keep your private health care or try
Yeah,
and figure out something in the interim. So
yeah,
yeah, I don't know a whole lot about that,
yeah,
except that a lot of people do struggle and or wait to see a doctor, unfortunately,
yeah.
until that Medicare kicks in.
Yeah, I know there's a gentleman I've interviewed before named Cal Hero, he's an insurance guy, but he deals a lot with this. He's been very helpful to my clients. He's got a website called Medicare Mall, if you're interested in that. And there's other people I know that deal with Medicare issues, and they deal more in the traditional Medicare. So you have sort of the Medicare supplement world and the traditional Medicare, and it just depends on your circumstances which one you do. So I typically refer out to somebody who knows more about it than me, because I just don't deal with that. I know.
Also, we don't actually even know that this is Medicare. It just says Aetna
Right,
health
Aetna,
insurance.
right.
This could be a Title 16 claim,
Yep.
and this person could
SSI.
have state Medicaid,
Yep.
run by Aetna. So there's not quite enough information there.
Right. Okay. Darren says, I have 12 months of accrued sick leave and vacation time. If I use up my wait from SSDI, will that cause any problems? No, because that is not work. Disability for SSDI, they're focusing on, are you going to work, doing some activity that you're getting paid for? If you're getting paid passive income from accrued vacation, that does not count against you. You may have to explain that. A judge may say, well, I see on the earnings record, you've got a year's worth of earnings, $50,000, $60,000 from ABC company. What is that all about? I try to catch those early, and I'll have my clients submit a statement that says that this, my last physical day of work was, April 13th, 2024. All earnings after that were accrued vacation or long-term disability or sick leave, whatever. But that you don't have to wait until that's used up before you apply for disability. Did that ever pop up at hearings?
Yes,
Yeah.
a lot. And this is why I recommend in my book, Social Security Disability Revealed, why it's so hard to access benefits and what you can do about it.
Okay.
All throughout the book, you need to have a representative, a qualified, knowledgeable representative. It's so important. And this is one of the many reasons why. Because if you don't have a representative, maybe you don't understand step one of the 5-step process, right? That they're going to talk about your earnings and the question of, can you earn substantial gainful activity? Have you earned substantial gainful activity? Let's look at your earnings report. So many unrepresented people don't understand that. And if you come into the hearing and the first thing the judge says is, I see $60,000 per year for the last 2 years on your earnings report. Are you working? And you say, well, no, I've been on leave. Oh, do you have any proof of that?
Mm-hmm.
You probably don't, right? Whereas
Right.
if you had an attorney like Jonathan,
Mm-hmm.
he would know, or she would know, to have some kind of documentation. No, this was vacation time. This was accrued leave. It's pretty easy to show documentation that you had this much leave. Here are your pay stubs. Here are your reports showing you using down the leave to show the judge, yep, this fully documented. This was accrued leave. The person was not working. No problem. As long as the judge has actual black and white evidence that was any kind of leave, vacation, sick, maybe you literally just got put on paid administrative leave. Good for you if that happened.
Mm-hmm.
Anything that's not work activity does not count because it's not substantial gainful activity.
Right.
And a qualified representative would know how to prove that. The judge
Yeah.
sees it and goes, okay, thank you. Moving on.
Moving on, right. And you don't want to create situations where a judge is questioning your truthfulness. Or I've seen judges that will try to bully people. Well, it says $60,000. That means you were working, weren't you? And you get nervous and you're like, well, you don't. I mean, it's think about it. Could you tell me what you were doing 3 years ago today? Probably not. People, not infrequently, the judge will say, "When's the last time you worked?" When they don't remember the year, because who's going to remember? Is it 23? Is it 24? Is it 22?
Right.
And
more common is
Yeah.
that you didn't just stop, right? You did this. You worked, your hours went down, they went up, they went down. Sometimes it was above the SGA, but for less than 6 months. That's really common, right?
Mm-hmm.
And that's why you have to have a representative who look at all that ahead of time and prepare a presentation, maybe even submit a pre-hearing brief to the judge saying, we've already analyzed this. Here's our analysis. None of these count as SGA. You asked me what I saw when I worked at Social Security. Admittedly, this is rare, but I did see times where the judge would stop the hearing at step one, say, I see earnings. You haven't proved to me that it was leave. I'm going to presume it was work activity. We're done. Denied.
Wow.
And the person would have to go hire a lawyer and submit evidence and go to the appeals council, all just, 2 years later, they're right back where they would have been had they been well prepared.
Yeah, no, that I've never had that happen to me, but I have seen, because I always look at the state agency decisions, and I have seen many state agency decisions where they see earnings and they will put on there, change the onset date, because they don't look any further. They just see earnings. Okay, well, there are earnings after the alleged onset date. We're going to change the onset date from January of 2023 to September of 2024. And then that sort of gets in the record. And, again, you've got to know to rebut that. And again, it can be something as simple as getting a statement from a former coworker, getting pay stubs, getting, your employment file. But yeah, that can be an issue.
Yeah, because what you just said is a great point. Because if you're on your own, you come to the judge and the judge is considering you as of September. I think you said September of 2024. But actually, maybe you should be entitled for an additional 12 or 24 months at a couple $1,000s a month. That's
a lot of money.
At some point, you're talking about real money, right?
Yeah, absolutely. Okay. Zippy says, I get worried about a CDR getting lost in the mail, never received it. Will it show up on my Social Security account that a CDR was sent? Thanks for all you do. So when you talk about a CDR, I'm not sure if you're talking about that they're sending you one or that you responded to it. I don't know. I know there've been some changes in the My Social Security account. I don't know if it says anything there. I just don't know. Maybe somebody else out here does, whether it shows that there's a CDR going on when you log into your My Social Security account. They will mail you paperwork, and it is not uncommon for things to get lost in the mail. No question about that. But I don't know whether it would show up otherwise, or whether you would have any recourse if they terminated you because you didn't respond to a long form or short form and you never got it. But that is
I think if you're receiving benefits of any kind, best practice is probably check that account often. Because I would be concerned about anything getting lost in the mail, right? Check that account off and look for a CDR, look for any appointments that have been scheduled on your behalf. If you have an appointment coming up with a doctor, maybe you had a CDR. Maybe you should look into that and call or write to Social Security and figure that out.
And make sure they have your correct address. If you move, a lot of people move and Social Security doesn't have a good address, let them know. And I mean, I would even tell people, send it in multiple times, send it in registered mail, return receipt requested. Don't just send it in once. I mean, right now, Social Security is somewhat chaotic, and we can talk about that for a second. I know you've been gone from the agency for a while. What are you hearing as far as what's going on there? I know you've got, I think you told me you had a relative or a friend who's still there. What are you hearing?
Yeah, I just want to say one thing about what you just said, because it's a great point. Not only send it in multiple times, but get tracking numbers and keep electronic evidence of everything, so that later, If you were terminated for some reason, you could say, well, wait a second, I was trying to communicate with Social Security on this date at this time. Here's the tracking number. Here's the evidence that shows I did my best to communicate with the agency. Because you're asking me what I have been seeing now, but I just want to say first what I remember seeing when I was with the agency. If something like that were to happen, it's the people who communicate with the agency and who, more importantly, can prove that they were communicating with the agency that end up having better outcomes. Let's say you're on benefits and you go back to work, or you're on the trial work period, right? Which the agency wants to support you returning to work. That's why there's a trial work period. You got to communicate your earnings to the agency. And I can't tell you how many people I would see their cases be terminated because, their earnings were too high, and they would have to come back and say, no, wait a second. I sent you this letter showing part of this was leave, part of it was work. Here's the date and time and tracking information. And judges love to see that, right? They want to know, okay, it wasn't your fault that we overpaid you, and you have proof. So documentation of everything in life, but specifically when it comes to Social Security, is just really, really important.
Yeah. Well, so what are you hearing about what's going on now?
Not a whole lot with regard to Social Security, just because I have been out of the agency for a few years. But the people I do speak to, and this is anecdotal, so I don't know if the numbers nationwide support this, but 10 years ago, we kind of were at the peak of the baby boom, and we had the highest number of applications, the peak of the baby boomers pre-retirement age applying in their late 50s and early 60s for disability specifically. And then kind of as we came off of that, the denial rate went up and up and up. And since I left, what I'm hearing is that that's kind of still tracking, that as the number of claims goes down, judges feel like they can spend more time on each case. And if you have more time, to write an unfavorable. And so denial rates, unfortunately, are going up. And I say unfortunately, because as I talk about in the book, the number of people applying for disability who are like trying to game the system or defraud the system is like virtually zero. There's no fraud, waste, and abuse in the Social Security disability system. It's darn near zero. It's almost non-existent. Everyone who applies for Social Security disability truly believes they're disabled and has at least some degree of medical evidence to support it. And that's why I think it's so unfortunate that denial rates are going up, because I don't think that there's actually fewer people that are having severe medical conditions or an inability to work. I just think it's probably that judges have more time to look for reasons within a 500-page record to deny people, and maybe they didn't quite have that luxury, say, 10 years ago.
Interesting. All right. Alicia, who we just got a favorable decision yesterday. So Alicia, congratulations on that.
Congratulations.
Yeah, absolutely. When and if a CDR is requested in the future, am I on my own to provide doctor's appointments and such? Yeah, we got a favorable. It came in yesterday. I sent it to you this morning. As far as the CDR, basically you get a long form or a short form. The short form is like, 7 or 8 questions. And, I'm finding that if you're over 55, the odds of getting a CDR are just not that great. That's not the mark. That's not who they're going after. They're going after the 35-year-old who got approved who's with depression or anxiety. They're not going after a 55, 58-year-old with an objective medical problem. So I think that what I tell all my clients is, if you get the form, certainly let me know. Happy to review it for you. Maybe I'm just fortunate. I have a very, very few cases that we get approved that end up being subject to termination. And the few that are, it's because the person just stopped going to the doctor totally. So I would just tell you, not just Alicia, but anybody, if you get an approval, keep going to the doctor, keep copies of your records. If you get a CDR form, fill it out. Again, if you're my client, I'm happy to review it for you. If we got to a situation, honestly, it's only happened 2 or 3 times where we have to go to a hearing. The issue you run into is you have the option of choosing to have your benefits continue while you appeal the termination, or benefits stop. And if you have benefits continue, that becomes a problem in getting a representative because there's no past due benefits to get paid on. On the other hand, if you have benefits stop, you have no money coming in. So it's a difficult situation. I take those on a case-by-case basis, but I will tell you, Alicia, and we're not going to go into your specific case, I think it's unlikely you're going to have a review. And if you do, it's going to probably be a short form one. But bottom line is, as long as you go to the doctor, keep records of it. Should you get one, you reach out to me and we'll address that.
Yeah. Can I say something on that?
Yeah,
because
absolutely.
I want anyone who's looking at this question to, I think there's a little bit of a mindset here, and I'm about to do a little magic trick here that I think is going to make you feel, your listeners feel a little bit better here. The way I read this question is, when and if a CDR is requested, do I have to provide my own medical appointments? But actually, if you read it a little differently, it's, if I have a CDR in the future, do I get to provide my own medical evidence? And that's a big difference, because if you think of it as a chore, like, oh, I have to do this, you might not really be motivated to keep getting medical treatment. But if you think I get to provide my own evidence, that's going to be evidence that's going to help counteract or contradict the state agency doctors that, and I talk about this in the book, these state agency doctors that the agency hires, both at initial review and on CDRs, they're not neutral. These doctors are chosen and hired specifically to provide opinions that suggest that you are not disabled.
And these are the medical specialists that when the adjudicator gathers information, they send it for review with a quote medical specialist.
Right.
And this could be a pediatrician, a retired pediatrician. It
Right.
could be a urologist. I mean, it could be, a lot of times these are retired doctors who do this to make a little bit extra money. But go ahead. So
even the doctor they send you to go see one time,
the consultant,
those doctors are not randomly chosen. The states, the agency knows exactly who they're hiring, and those doctors know exactly what kind of opinions the agency wants if they want to keep getting referrals for the agency. And they spend like 10 to 30 minutes on those appointments and get paid hundreds of dollars. Mm-hmm. So those doctors love those one-time appointments. One of my doctors actually one time, while I was having an exam, he told me, yeah, I'm paying off my med school loans by working for Social Security. He said I would come in on a Saturday and my staff would take 4 rooms and I could do 20 people in a day and just go from room to room and think about how much Social Security is paying him for all those 20 people in that one day. He knows what they want to see. He knows Social Security wants an opinion that those people can work. And so those are not neutral doctors. So it's really important that to think of it like this. It's not that you have to keep providing evidence. You get to go see your doctors who know you best and can help you build a medical record and give you medical opinions saying, I've been treating this person for years and I know my patient. And I know my patient cannot do full-time work, something like that. So, if you think about it like that, the fact that you get to submit your own medical evidence at a CDR, and that could be really helpful for you.
Interesting. You mentioned talk about the consultative doctors. My experience has been that the internal medicine consultative doctors, physical medicine, are typically like the industrial clinic doctors who may have an office in a strip mall someplace, and they do a lot of work for insurance companies to deny insurance claims.
Yep.
The psychologists tend to be, in my opinion, my experience has been a little more reasonable because they're typically practicing psychologists, and their mindset is that everybody has a psychological problem.
They're also spending more time with the person, 45 minutes, an hour. But yeah, you're right. The internal medicine doctors, like the doctor that I was seeing, he was a resident with med school loans. He wasn't being paid that much as a resident. And that's why he would take weekend cases for Social Security. And he would tell me, like, I get paid. I couldn't work as a resident if I didn't have those Saturday cases from Social Security.
Wow.
Where I'm spending 10 minutes in each room. And at the end of the day, I just tell the agency all these people are not disabled.
Let me ask you about as you know, there was something that was the law until a few years ago called the treating source rule.
Yeah.
Basically, for those who don't know what it was, it used to be that the Social Security was required to give controlling weight to the opinion of a longtime treating doctor as opposed to the opinion of a consultative doctor or a non-examining doctor. In their infinite wisdom, they got rid of that. I don't know, it was maybe 8, 9, 10 years ago.
Mm-hmm.
In your experience, would judges really give more weight to a consultative doctor or a non-examining doctor when there was treating source evidence? Even
It depends. If it's an unfavorable decision, yes. Yeah. If it's a favorable decision, no, right? Not so. I was at the agency for several years before that rule change and several years after. Nothing really changed, to be quite honest. Before, when they had that rule, yeah, they were supposed to give a lot of weight to your treating source unless there was a contradictory opinion. And so they could come up with all these reasons. Well, your treating source knows you. They have a personal relationship. We're not sure how honest they're being. But the doctor who saw you only one time for 10 minutes and who knows nothing about you, that person we're giving a lot of weight. It would make no logical sense. But if you want to deny a case and those are the only two opinions, that's how you do it. That's how I, as the decision writer, would have to write it, whether I liked it or not. That's the judge's decision, right? But the good judges, no, of course the good judges wouldn't do that. The good judges then and now would look at a treating source relationship over time and say, well, wait a second. This person has seen you for many years. They've seen you many times. They've examined you more than once. They've looked at your test results over a long period of time. That's the person who knows what you can do, knows what you could do then 4 years ago when they started seeing you, and they know what you can do now. The person who saw you for 10 minutes, you were just a statistic. There's no reason for me to believe that person. A good judge will do that. But if that would, if your treating source says you can't do a full-time work schedule and the state agency consultant says you could do light work, a lot of times it just comes down to if the judge wants to deny the case, they'll find this doctor more persuasive. And if they want to approve it, they'll find this doctor more persuasive.
What was the impact? I don't know if you were there when the whole Eric Conn thing was going on.
Yeah, I was.
What was the impact on the agency? And just for those who don't know, Eric Conn was an attorney in, I don't know, was it West Virginia or
with a very appropriate name.
Right, Eric Conn. And so basically what this guy did was he had a deal with a judge and some doctors and some staff people, I think at Social Security, and he had all these cases assigned to him. The doctor would write a report, or he would write the report for the doctor, basically saying the person's disabled. It would go to the judge. The judge would choose those cases. Yep. And Mr. Conn, basically ripped off Social Security to the tune of several $1 million. This comes to light. He gets arrested. Then he cuts off his bracelet and he goes on the run to South America.
If you've never seen the documentary, it's fantastic.
It's on, I think on Netflix or something like that. The point, though, is that what ends up happening, at least in my view, is Congress sees this and they overreact. And they basically, there's so much fraud here. This is a one-off. So my question to you is, what was the impact at Social Security? Did it just change the way things? Because it seemed to me that's when we started seeing a real decline in the approval rates. And you started to see Congress really taking an interest in kind of making this assumption that there's so much fraud there. Is that what you observed?
I want to give Congress a little bit of credit here, because if Congress was really going to do that, there's a lot more they could have done in terms of tinkering with the definition of disability or shifting the age categories. They, instead of being 50 and 55, they could have said, okay, we're going to pass a new law. Now it's 55 and 60, right? They could have done more. Mm-hmm. So I want to give Congress a little bit of credit, because the members of Congress on the committees, specifically the Senate committee that works with Social Security, at least when I was there, I found that they had a lot of really good questions for the agency. Having said that, the agency obviously did make some internal changes. And a lot of this, just to put a period at the end of the sentence. A lot of those cases that Eric were part of that whole Eric Conn thing had to get re-reviewed just to make sure people getting benefits were supposed to be getting benefits. So those did all get reprocessed.
Mm-hmm.
But I think the overall impact was everyone was just a little more careful. Not that people needed to be, right? Because this was such an isolated incident. It was one judge, and I think maybe even one doctor and one attorney, and they were cranking out a lot because nobody figured this out for quite a while. But it's not like it wasn't a widespread problem. Like I said, there's virtually no fraud in the system. And by the way, including with those cases, because the claimants, the clients of Eric Conn, they didn't know what was happening.
Right.
They just thought, I've got the best attorney in the country. They didn't know. So unfortunately, a lot of them were given benefits, and then those benefits were taken away.
Yeah. And really the sad part is there's a large number of suicides, people that were given benefits, they cut them off, and it took a couple of years before they got a chance to have their cases. And in one of the poorest parts of the country, unfortunately. Right. But for, every other representative and every other judge and every other hearing office, I talk about this in the book where, everyone has an opinion about what fraud, waste, and abuse is. And I don't want to get political, but I think a lot of people have this misperception about how government agencies work, especially big ones like Social Security. This is one of the biggest, if not the biggest part of the federal budget. But it's so big because there's over 1 million claimants a year, and you've got several hundred hearing offices and over 1,000 judges. Like, it's big because it's just an enormous system. It's not because people are sitting in the beach eating lobster collecting Social Security. You just can't do that. Like, people actually look at the evidence. So, if you see a news story or something about someone defrauding the government, you're seeing it in the news because of how rare that case is and how much of an exception to the rule that is. 99.999% of all employees, claimants, representatives, and judges, you might disagree with their rulings or their findings. There's some high-paying judges, there's some low-paying judges, but they're not committing fraud, right? They're not doing anything wrong. So maybe you had higher paying judges or lower paying judges that were not near the bell, on the ends of the bell curve, where they would pad their decisions with more evidence. They would make sure they were very clearly justifying their decisions, just so everyone understands, like, this is why I'm paying it, or this is why I'm denying it. But again, those were all based on evidence. So, we didn't really have to make a whole lot of changes because almost every Social Security, if you're working honestly and you're honestly trying to analyze the evidence and come up with the right decision, you don't really have to change a whole lot. You just maybe make sure there's a little bit more information in that decision, so the representative and the claimant and the appeals counsel and the federal courts more fully and thoroughly understand your decision. Got it. All right, let's continue on. We have JTLBZ. Just want to thank you. You're very, very welcome. Rock says, sorry I missed your call. Yes, give us a call back. That would be great. Thank you. I appreciate that, Rock. That was much, much appreciated. Very nice words. Absolutely. We are have the 5 to 7. Okay, so basically we have a case that we won. A claimant is 59 years old, have a 5 to 7 year diary. Do I need to get my file for winning? Do I have to call you? Well, first of all, let me ask Spencer, when we talk about cases being diaried for reviews, do you know much about that? What that means?
So there's a couple, I know a little bit, not a lot, but I know a little bit. So sometimes at the end of a decision, anyone who's seen a decision may have seen this, because it's not in all of them, but sometimes, Jonathan, you know this, sometimes it'll say at the end of the decision, the judge will say, I recommend this case be reviewed in 12 months, 24 months, 36 months. That's boilerplate language.
I had one of those 2 weeks ago. Yeah.
Just click a box next to 12, 24, 36, whichever one the judge wants. And that's the judge's decision. Mm-hmm. But in practicality, those aren't really needed. It's kind of more, as you said earlier this evening, it's really more based on your age. So if you're over 50, it's unlikely that your case is going to be diaried at all, because we are all afflicted with the same medical condition, and it's called getting older.
Not me.
And so
Not personally. I personally have decided not to buy into that
so
at all.
if
Everybody else decides.
if you're 50, 51, 52,
Yeah.
it's not like you're ever going to be under 50 again.
Right.
The agency, they know how to use resources efficiently. A lot of people think, oh, government inefficiency, right? Actually, the government's really efficient. And this agency, like a lot of agencies, they know how to use their resources to be the most efficient. And that's why they won't review cases if they think this person's unlikely to come off of disability between now and retirement. Why are we wasting time and energy and doctors? Because they have to pay doctors to review your case on a CDR. Let's focus on the people who may or may not be able to come off of disability and go back to work at some point. So the younger you are, the more likely your case is to have a diary. And the other thing is it's based on your impairments, right? I know someone who was unfortunately in their 20s and had a traumatic brain injury. That's not going to get better. That case probably isn't being diaried at all. And if it is, maybe it's one time. They see that that person didn't improve, and that's it. They know that that's a permanent disability. Whereas if you have a back impairment or a shoulder impairment or something that you could get surgery, the whole point of surgery is that hopefully you come back from it, right? So if they think it's something that you're young enough and you're able to recover, they might set a date for a couple of years down the line just to see if you have recovered. And that's reasonable, right? Because as a whole, we want people to try and encourage people to get back to work if they can. You were talking to me earlier about how it's just good for your health and your mental health to be able to work if you can. And people, the vast majority of the people who receive benefits do not want to receive benefits. They want to work. They do their best. They try their hardest. They're receiving benefits because they can't work. Not won't, can't. So the people who can maybe sometimes do. That's why the trial work period exists. And that's why the agency wants to give you that opportunity and see if you can go back to work. And those cases are the ones that are more likely to have a diary date set to go back and review it and see if that person's improved.
And by the way, when we talk about a diary of the 5 to 7 year, there is a provision in the student loan law, because the government now issues all student loans, that you can get a disability discharge for your student loans if you're on a 7-year review, not on a 1-year review, but I think it's a 5 to 7 review. So basically, this is another indicia that the government considers a person who's in a 5 to 7 year review. It's probably permanent. And the thing that might trigger it would be, again, the age. I think also if they see earnings coming in, if they see you're working, that might trigger it. If there's any evidence of medical improvement. I mean, people, and I will tell you this, I've had a number of cases where, a nosy neighbor decides they want to create trouble, or an ex-spouse wants to create trouble. They write a letter to Social Security. Joe here is getting benefits.
This is very common, by the way.
Really?
Very common.
Interesting. Tell me. What when you say it's common?
Yeah, so I also did CDRs, both at the Appeals Council and at the hearing level. And of course, if I'm seeing a CDR at the hearing level, well, actually, if I'm seeing any case at the hearing level, it's because it was denied by the state agency. But if I'm seeing a CDR at the hearing level, what do we know? We know that person was at some point approved, and then a CDR hit, and that's now been flipped to a denial, and then it comes to the hearing level, right? So, and that's every CDR at the hearing level. So I know, okay, why was this person approved and what changed? And I would get information about what triggered the CDR, and I would be able to see those letters because they go into the record, into the E section of the file, right?
Okay.
And yeah, you it happens a lot. Maybe it's law enforcement, or someone who's in the military and they know you're a neighbor, or they know you from church or something, and they're like, this person told me they're on disability, or I heard a rumor, and I just want you to know they're volunteering, they're doing this, and that, I guess you kind of just have to assume that the agency doesn't like have scouts and they're not like watching you, but you kind of have to assume that CDR could come at any time. Keep getting your medical treatment, keep documentation of everything, especially if you communicate with the agency. If you take an umbrella and you wear a raincoat, it might not rain. Right. So if you're well prepared, you might not get a CDR, but if you do, you'll feel a lot better about it.
Yeah. So again, I think what you're saying is that, when you get approved for disability, it's nobody's business. Don't post about it on Facebook. Don't post about it on Instagram. Just really stay off social media in general.
Yeah.
Don't tell your neighbors. Don't tell acquaintances. Obviously, your spouse is going to know. But I mean, this is nobody's business, because there are people out there who take it upon themselves to be, the conscience of the government. They want to, they feel like there's too much fraud. I mean, I'll get these emails from people, comments on my videos. Everybody knows that most people on disability are fraud.
Yeah. I mean, I have a whole chapter in my book about that, by the way.
Wow.
About why that's just uninformed nonsense.
Yep.
And but I want to say one other thing. You said don't tell people about it. It's no one's business. And you know what? A lot of people actually do follow that advice. Mm-hmm. If you look at how many people are receiving Social Security disability benefits nationwide, I talk about this in the book. Statistically, people who are receiving disability. Mm-hmm. Everyone, we all know someone who is receiving or has at least applied for disability benefits.
Yep.
You just don't know, because they're not sharing it with you because it's none of your business.
Right.
Or they're embarrassed or they don't want to talk about it. For whatever reason, they're not sharing about it. And that's probably, honestly, as you said, in their own best interest to not talk about it. But we have people who have applied for Social Security in every state, in every city, in every community, all across the United States.
Yeah.
It's not that rare.
And there's nothing to be ashamed of. I mean, look, you paid into the system. You have a diagnosed medical problem. Look, I think it's probably one of the more difficult things for anybody to do is to say, I am disabled, to label yourself as being disabled, and to give up the financial benefit of working, the social benefit of working, just feeling, I mean, people say to me things like, I don't feel like I have any value to anybody anymore, and it's not the case, but I mean, it's a really hard thing to do. So nothing to be embarrassed about. I mean, and this is why, I think that if anything, getting on benefits, you can live with some dignity. You're not getting rich on benefits, but you have a little bit of
no one is getting rich on. I talk about that in the book too. Yeah. That it makes 0 sense to risk federal crimes, prison, many years in jail for the tiny amount of benefits, and that's if you're even approved.
Right.
And here's the thing, it's an insurance program.
Yeah.
If you have a car and you have car insurance and you're in an accident and you wouldn't hesitate to have your insurance company pay for damage to your car, why would you hesitate to have an insurance company pay because you have a medical claim? It's really not that different. Social Security, disability, insurance, SSDI, it's an insurance program.
Right.
Hopefully you'll never need it. But if you do, it's there. And that's why you're paying that premium every 2 weeks in your paycheck. That premium comes out of your pay, whether you want it to or not. Even if you're self-employed, it's called the self-employment tax.
Yep.
You're paying the premium. If you need that insurance, that's why it's there for you.
Okay. All right. So I mentioned at the outset, Spencer's made available his book. We're going to give it away and we're going to talk about the book in a second. But if you want the audio copy, I'm going to give you we're going to do a little contest. My email is ssdanswers123@gmail.com. If you email me, and I've talked about this the last couple of weeks, I was in another location. I was in a different state for a wedding. And I talked about this a good bit in the last couple of live streams. So it's online if you want to look it up. But email me with the place I went 2 weeks ago for a little vacation. I have all the correct answers. I'll choose one randomly to give you the code for the book. So send me an email and let me know where I was a couple of weeks ago for this wedding. It's cooler than Atlanta. Cooler meaning it was temperature-wise a lot cooler than I'm here in
Yeah, because
Atlanta.
everywhere's cooler than
Right,
Atlanta.
I know. But it was a nice little trip. But if those of you who know where I was, email me, and I'll choose from the correct answers. I'll pick a winner, and for one of, I think you said you've got two
Yeah,
of these. So okay, so
we're
for
going to
the
give
first
away
one,
2
that,
audiobooks.
that's the question for the first one. I'm going to give you another question in a few minutes, but
And please only try to get the audiobook if you like the sound of my voice. Well, even if you don't, I guess. But I'm the narrator of my own audiobook. So get used to this for 7.5 hours if you want that audiobook.
Yeah, it's interesting. I've become a much more inclined to listen to podcasts and audiobooks. I read a lot, but also I've got my dog. I got a 70-pound golden doodle, and not so much in the summer because it's too hot for her, but in the fall and in the winter and the spring, we'll go on a 4 or 5 mile walk.
Right.
And I will, be listening to an audiobook, and it's a great way to learn things. And there's really a lot.
For me, it's walking the dog, doing dishes, and doing the laundry. And yet, when I was a kid and I was in school, when they would say like you have to read a book, it meant one of these, right?
Yeah.
But with technology the way it is, but also this is apropos to our discussion, right? Because so many people have medical impairments that make it hard to read. It could be a visual impairment. It could be concentration impairments. There's all kinds of different medical conditions that make it really difficult to hold a physical book or even a tablet. And that's why when I wrote the book, I thought it's really, really important that I get an audiobook out, because there's so many people who just can't read a book. But I want everyone to have access to this information, to understand how the system works, how it doesn't, what people do right, what people do wrong, and all the different things you need to do in order to set yourself up for the best chance of success in your Social Security disability case.
All right,
and that's why the audiobook was so important to me.
All right, and we're going to go into some of that just in a second. But let's answer a couple more questions.
Yeah.
Catherine says, I applied for SSDI in November of 2024. I had a CE in June, I guess, of 25. When I tried to check the status, my application is not showing on the website. What does this mean?
This is why people love government right here.
Yeah, it's a red flag is what it means, because something's not right. And what could have happened it could have been that a decision has been made, you just hadn't gotten it yet. It could have been a decision was made, they didn't tell you, or you never got the letter, and the case has been closed. What it says to me is you better follow up. You got to find out what's going on, because when you're checking status and it says application's not showing, that is a red flag to me.
And what happens if your case was denied? You have a very limited amount of time to appeal.
Yeah.
And if you miss that appeal deadline, you could go back and appeal and say, I never got the decision, but you're going to have to prove that.
Yeah.
And that can be very hard to prove.
Yeah. Yeah. I mean, I've had a number of these where we'll file a request for late filed, appeal.
Yeah.
And, I've pretty much got if it's within 2 or 3 months of the deadline, I'm usually successful with that. If it's more than that, it starts to become a little iffier. So,
and I just want to say one other thing. Just statistically, I talk about the statistics in my book, and my understanding is, if anything, they've gotten worse for claimants. Statistically, you're not going to be approved. About a third of people or less are approved at the initial level nationwide. So if you saw a CE, a consultative examiner, that doctor that you go see one time, like I said, those people are not randomly chosen. They know what the agency wants to see. And a lot of time the agency wants to deny that initial determination. And so just statistically, you were denied. And that's why it's even more important. It's not a 50-50 toss-up. Right. It's more likely that you were denied than you were approved. And that's why it's even more important that you follow up.
Yeah, well, I will tell you that, statistically, Social Security produces something called a waterfall chart, and I have it on my blog at ssdanswers.com/blog every year. And, last year, I think 2024, about 33% of applications were approved at initial.
Yeah, so that's pretty consistent. I talk about that in the book.
But most of those are people with, listing level impairments. They are terminal cancer. It's not your average. I mean, it's not it's not most people that are, functioning. These are
Right.
people who have really something very, very serious.
Yes.
Recon is about 15, 18%. And then
That's surprisingly high to me. It used to be a
yeah,
lot lower.
yeah, it's gone up a little bit. And then at the hearing, it's kind of hovering in the 48%
Yeah.
range. It was 41. Now it's kind of gone up a little
That's a
bit.
great point, though. It's not a random 1/3 at the initial
Mhm.
level.
Right.
I told you I know someone who has a traumatic brain injury. Unfortunately, that person was approved at the initial level because there were thousands of pages of medical evidence that it was so well documented. Yeah, terminal cases, people who have cancer, people who were spending lots of time in the hospital, people who are over 60. Yeah, if that's not you, there's
Yeah.
even more of a chance that your claim is going to be denied at the initial level.
But the point here is that when you get that denial notice and it's a form letter, it's going to make you upset. I mean, it's just going to make you
Yes.
upset because you have this form letter that says, we've reviewed your file and we've decided you can work. And then you look at the bottom and the last page and it'll say, well, we got these records, but we didn't bother getting, or we never got the records from your treating orthopedist, the person who did surgery, your neurosurgeon, your psychiatrist.
Mm-hmm.
But we do have this CE report, and we've got a hospital you visited 3 years ago or something.
Yeah.
So,
And we think you can do these 3 jobs
right,
that you've never heard of.
right, exactly. So don't get upset. You just have to appeal. This is it's a bureaucratic system. It's going to make you upset, but don't, ball it up and throw it away and just, then reapply. You want to appeal or at least talk to an attorney about appealing because, and you got to do it quickly. You have 60 days to file an appeal. And, sometimes the date on the letter will be, let's say, June 15th. It won't get mailed out for 2 or 3 weeks. So they assume 5 days from the date of that letter is when you got it.
Right.
So look at the date on the letter, and you don't have a lot of time. But you got to appeal it.
And the other reason, don't ball it up and reapply. Some people can't reapply.
Yeah.
Right. Like if your DLI, if your date last insured passed, that decision you're stuck. You're can't
stuck.
Reapply at all. So it's really important to, educate yourself, make sure you know what you're doing,
Yep.
have a good representative in your corner, and have a strategy for how to move forward. This is not a passive process. If you want to get benefits, you have to be a very active participant and you have to go get the benefits to which you're entitled.
Yeah, you're right. You can't just sit back and wait for stuff to happen. You've got to go to the doctor. You've got to tell the doctor what you're doing. It can be very difficult sometimes to have that conversation with your doctor because on one hand, if you say I can't work, are you not telling the doctor that the efforts you're making on my behalf are not working? Right. But on the other hand, if you can't work, you can't work. So you have to, and many doctors are very suspicious about people pursuing disability. They think that means you've given up. I mean, I know there's a doctor here in Atlanta who is well known for treating fibromyalgia, which is a whole different issue here. But and if you look at that doctor's website, I think it's a rheumatologist. It says, we are an ability practice, not a disability practice. We are not the right place for you.
Right. Don't ask us to sign the form.
Right.
Yeah. And I haven't said this yet. Can I just say one more thing, Jonathan?
Absolutely.
I want people to know.
Yeah.
I wrote this book when I left the agency because I wanted people to understand the process. It's not to get clients. I actually don't take private disability clients. I am not in the social. This is not a way for me to get you to come to me for your case. I actually don't do Social Security disability in the private sector. So I'm not providing this information because I'm just trying to get you as a client. I wrote this book because I genuinely want people to understand, here's all the things that you need to consider. And one of those is you need to have a representative, not me, someone else who's a really good representative like Jonathan, who knows the ins and outs of the system and knows all the places that the system is designed to trap you. People fall into traps at various points. For example, missing the appeal window. That's not by accident. The appeal window has a limited amount of time on purpose. They want people to miss the appeal window because then it's fewer cases, right? They want people to not know certain things because that helps them easily deny and dispose of cases. And that's why it's really important to educate yourself, to be an active participant, and to have a really good representative.
That's actually one thing I remember when we talked on our podcast several years ago,
Yeah,
that, this is not a neutral situation. Not the agency is not neutral. It is
right,
designed, to make it hard to. People say to me all the time, "I paid into the system for years. Why do they make it so hard for me to get my money out?" Because they don't see it as your money. They
right.
see it. Congress sees it. It's our money. And we want to spend it on other things, and we're going to begrudgingly give it to people who, we have no choice but to give it to. So don't approach this thinking, well, they want to be fair with me. That's not what this is
Right.
all about.
They do not. And just practicality
Mhm.
purposes, there's a very limited amount of money.
Yeah,
It's the same pool of money for Title II Social Security disability insurance and for retirement benefits. And there's a lot of people who are
yeah,
reaching 62, 65,
yeah.
67 and retiring. They have a very finite pool. It's a very large pool, but it's the entire country,
But it's going to
right?
run out of money in 10 years. I mean,
I don't
well, maybe.
I don't
Okay.
agree
Yeah,
with
okay,
that
okay.
because Congress always seems to come up
Well,
with a fix.
they have a fix. If they don't do anything,
But this is one of the ways that
right?
they help that to not happen is by limiting who gets Social Security disability benefits. And the younger you are, the more important that is. Because if
Yeah,
they give a 25-year-old benefits and that person has, say,
40,
traumatic brain injury, they
right,
could be
40
on
years.
benefits for 40
Right,
years.
right.
And so they're not saying, oh, we're just going to deny everyone. They will pay claims that are well supported, but you got to make sure your claim is well supported with medical evidence. And that is no easy task.
Yeah, yeah. Well, and again, I look at the CDR process, and again, they give you this choice. If you want an attorney, you've got to basically agree not to get benefits continue. But if you want benefits continue, there's no way to get an attorney on contingency.
Right.
Is that really fair? No, but it makes it impossible for people to get an attorney if they want to have money coming in for the next year and a half.
Yeah, it's a really difficult. I've
Mhm.
seen a lot of overpayment cases, and that it's a really difficult decision
Yeah,
that people have to make because if that's how you're paying your rent and buying food,
right,
we've talked about this is not a lot of benefits. You're not
right,
eating out, right? Like this is rice and beans and ramen and living a very, very basic lifestyle with Social Security disability, but you at least have something. And I can't imagine what it would be like to be put in that place where you have to make that decision,
yeah,
to risk an overpayment because those can, if you get an overpayment, when you turn 67, you hit retirement age, they can take your benefits
right,
if you owe the agency money, right? So
right.
it's a really big and a really important decision.
Absolutely. Absolutely. All right. Rock says, I may have put the wrong onset date in my application. As I stopped working several years ago, I listed it as August of 23. It should have been closer to 2017. All right. So you raise a couple of points here. One is you need to find out your date last insured.
Yep.
Because if you stopped working in 2017, there's a good chance your date last insured is 2021, 2022. Your onset date needs to be before your insurance runs out. And so you've got to get your My Social Security statement to find out. Although, again, they don't tell you your date last insured. You can kind of run the number. I can run the numbers and see. But that is one point, is to find out what your date last insured is. And the
Yep.
other point is when you apply, if you apply in 2025, you only get paid 1 year prior to the date of application.
That's
So
right.
even if you prove your onset was 2017, you're not getting paid back to 2017. It's only 1 year prior to your application. But most important thing is, what is your date last insured? Because it's like any other insurance policy. If you have car insurance and it ran out May 31st and you have an accident June 5th, you got a problem. So that's sort of
Yeah.
the same thing.
And agency employees are trained on how to look for both of those things. So one of the, very early on, I got trained on how to both manually calculate someone's date last insured, but also in every case, we're looking at, 17 months or 18 months back because
Right.
there's the Title II waiting period.
5 month
So
waiting.
you go and you look for the application and you count 5 months and you go to the first of the next month plus 12 months to figure out when that person would be eligible for benefits. But the other thing is, a lot of people will say, I stopped working in 2017, 2018, but they didn't really, right? Like maybe they left their full-time $100,000 a year job, but they've been working part-time or for their church or for family or self-employed, and they're earning a few $1,000s a year. it doesn't take much in order to get 4 credits. It's like
Right.
$6,000 a year, and you get those 4
Right,
credits.
actually, I always tell people about 7,500 to get
Yeah,
through.
and that pushes your DLI forward, which just
Right.
can help you, right? So
Right.
just another reason why it's so important to have a representative who knows what they're doing and who knows how to calculate that for you. Because when you get in front of the judge, if you have the wrong onset date, you're giving up benefits, right?
Yeah.
If you say, oh, I've been a disabled since 2023, but let's say actually you could be paid back to 2022 or 2021, you got to tell the judge, I want benefits back to that point. I want my maximum benefits that I'm eligible for. And if you somehow mess that up because you didn't understand how these dates work,
Yeah.
you're leaving money on the table that you are statutorily entitled to under the law.
Although I will tell you, it is difficult at a hearing to say to a judge, actually, my onset date should be 18 months earlier, because at the administrative level, they're supposed to gather evidence. There may not be evidence going back that far. And I've had judges, it's been a long time since this happened.
Yeah.
The judge says, I'm going to go ahead and stop this hearing and send this case back to the state agency for adjudication to find out, to develop the record going back to that earlier onset date. So if you're going to try to, and it doesn't happen much, but if you're going to try to argue an earlier onset date, the sooner you let them know, the better. And ideally, while it's at initial,
absolutely,
not at the hearing.
Absolutely. Always changes of information the agency needs to know as soon as possible. I will say this, when I was at the hearing office, maybe the judges I was working with deserved some credit on this one, because they would understand, oh, this person didn't have a representative at the state agency. Now they have a representative, and that representative is telling us it should be an earlier onset date and giving us a good argument as to why. Those judges would often go ahead and say, okay, I'll get your testimony now, get me your medical records. I might need to get a medical expert to evaluate them, but I would often not see those cases sent back. The judge would say, okay, it's a de novo review at my level. That just means a review from scratch. I don't have to worry about what happened at the state agency. I'll go ahead and develop the record for you since you're now in front of me. And you were insured at that time, you're entitled to benefits, so I'll give you a fair valuation of that period of time. And so this is, again, we come back to different judges in different places do things differently, and you have to be prepared to go in front of any judge anywhere in the country.
Yep. No, true. Not every judge would do that. No question about it. Not every judge would do that. And by the way, speaking of the date last insured, one thing I just learned not too long ago was, when I get a file, there's like it's the best way to put it, it's like a table of contents. It's got all the exhibits. And basically what I'm looking at is exhibit A, B, D, E, and F. Exhibit C.
Yeah, there's nothing in C.
Nothing in C. Okay. So we get A, B, D, E, and F. And so at the table of contents, it'll say the date of application, date last insured. That can be wrong.
It's often wrong.
It's often wrong. So if you don't, and what you got to look at is there's a detailed earnings query or something. I forget what it's called, but I think it's in section B or D or something. But that's going to have the actual date last insured. And I had a case earlier this year where my client had applied, and he had a medical problem, but it resolved itself. Then he had a major stroke. But it was after the date that's showed in the table of contents as a date last insured.
Yeah.
I'm thinking, I got a big problem. And the judge actually said to me, because I said, Judge, I'm looking at this. I did a pre-hearing call with him. I said, I think I've got a problem here. I don't want to waste your time. He goes, no, look here. You'll see the date last insured is actually December of that year.
That's right.
You're okay. And it taught me I got to look in a different place. I can't assume because it's on that table of contents that that it's right. So
here's how often it's wrong.
Yeah,
we were trained to, in every single case, pull a new report. Every single case that I reviewed while I was at Social Security, especially at the hearing office, to pull a brand new DLI on every single case. I would say it's wrong a vast majority of the time. Well,
Really?
no,
Okay.
often the person's still working, and so it's in the future. But
Yeah.
where it's in the past, it's almost always wrong. And the reason, if you're wondering why, is lag earnings.
Right. Right.
It doesn't. What'd you say? $7,000 earns you
Right.
all 4
Right.
credits. A
7,500,
couple,
like 7,300, but yeah, so let's say
couple thousand
round up
gets you 1 or 2
75.
credits, though, right?
Right.
And so between when you apply for Social Security and when you get your hearing or decision, if you've been working part-time, you're still earning credits. And that's why, even though maybe you thought it was in 2022, but then it shifted and you earned a couple thousand more, and it shifted and it shifted. And now it turns out that the person had that stroke and it was 2 quarters after that because they were working.
Right.
And as you keep earning credits, it shifts your DLI, your date last insured, forward in time. Right. And the hearing office staff, they're trained in how to do that. And that's probably what happened in that case.
Yeah.
Is the hearing office staff pulled a new one and said, oh, the DLI is not in the past anymore, or is in the past, but it's at least later in time than it used to be. And maybe they even noticed when they were developing the record, that evidence, and someone maybe called that to the judge's attention, or the judge found it themselves and said, okay, I see the stroke, I see the DLI, I'm going to focus on that at the hearing. And so by the time you brought it up, it was already on their radar.
Yep.
But yet again, you don't know if that's going to happen. You
Right.
don't know what hearing office you're going to be at. Yet another reason why you got to have a representative who knows what they're doing.
Part-time work. What in your experience, is it ever dangerous to work part-time while you're applying? I mean, these cases can take 2 years, 3 years. Is it ever, I mean, I always thought, my opinion was that if, let's say, SGA, or substantial gainful activity, is
right,
$1,620 a month gross in 2025.
Yeah.
If you're working part-time, earning $1,600 a month after month, that's potentially problematic. If you're earning $1,200, $800, it's not as much a big deal. What's your take on that?
Here's the thing. There's a couple different ways to look at that. I don't know if dangerous is the right word, because a lot of times you have to remember the judges want to see that if you can work, that you're trying to work. And, they might ask you, well, you were only working how many hours? I was working part-time, 10 hours a week. Well, why? Why couldn't you do more? And now what if they see you earning just under the SGA amount? They get a little suspicious, right?
Mm-hmm.
Why weren't you working more? Oh, your pay went up and you started working fewer hours? Explain that to me. So the thing is, and then of course, if you're approved, the trial work period amounts are even lower. You got to be even more careful. But ultimately, like we've talked about already, people want to work. Most people are not trying to not work. They don't want to mess themselves over when it comes to benefits, right? You have to do this calculation and decide, at what point am I risking losing benefits or not being approved? And there's something called, you get 6 months to try and go back to work before it becomes an unsuccessful work attempt. And then there's the trial work period, which is, up to 9 months, but
Right.
Complicated. We don't need to get to it here.
Right.
But the thing is, representatives know how to do these things. So I wouldn't tell the person applying, I wouldn't tell the applicant, don't work. But what I might say is, look, if you've either already applied or you're thinking about applying, go talk to a representative like Jonathan, because they can look at your specific situation. What's your hourly rate? How often do you work? Is it seasonal? If you're working in the holidays in November and December, and that's going to be over by January, it's not going to be a problem. It's less
Right.
than 6 months. But also, even if it's less than 6 months, the judge is going to look at that and say, wait a second, you worked the whole holidays and you were standing on your feet and you were lifting, boxes. That maybe suggests to the judge that you could do that. So you have to talk to a representative.
It's case by case.
Case by case. And you got to talk to a representative so that representative can say, okay, you brought up several issues here and we got to talk about all of these and let you know. I don't think anyone would discourage. I mean, this is a question for you. I don't know that you would discourage someone from working.
I would not. What you don't want to do is you don't want to work so much where you work too much to take yourself out of the disability process, but not enough to make a living.
You got to exactly. You got to be careful and understand the ramifications of that work activity and how it's going to present, both with regard to step one, as substantial gainful activity, but also with regard to showing the judge what you can do. Because if you do more, and maybe you don't think I can't lift, but you do it anyways over the holidays. And then, all of Christmas and New Year's, you're lying flat on your back in bed because you overdid it. You don't want the judge to think you can do something that you can't do on a full-time, regular and continuing basis. So that's why you really need to have a representative who knows what they're doing, analyze that situation.
Got it. All right. This was an interesting question. Jay's Beer says, I'm military. My judge is military, so it's an easy win for me. Raises two questions. I mean, the question whether anything is really an easy win. But my question is, is that the case? If somebody, your observation, if somebody is ex-military, and by the way, we all appreciate the services of our military.
Yeah.
Does that give you an advantage? And then the second question is, what is the value, or what is the importance or relevance of 100% VA disability rate?
That's where I was going to go with that. Yeah. So just to comment on the comment here, I don't think this, I'm glad you were approved, but it's not because you were in the military and so was the judge. It's because your case had medical evidence supporting a claim for disability. The fact that you and the judge were both in the military is a coincidence.
Mm-hmm. Doesn't hurt.
I don't know that it necessarily helps, except what you were suggesting, which is that people in the military often have extremely good health care. We don't have single payer or single provider healthcare in the United States unless you're in the military or in prison or in the military, right? Where it's the military. And then once you get out and you're a veteran, VA. So while you're in the military, I've not served in the military, so I don't know the ins and outs of how it works, but I know they get really good healthcare, really good evaluations. And then of course you can be evaluated for a certain percentage of disability, which it doesn't directly relate to Social Security because that's about your VA, your benefits, but Social Security judges do consider that to be very good evidence of your ability to work. Now, again, it doesn't really translate because even at 100% disability, what that's saying is you are unable to do a job within the military, whereas Social Security is asking, can you do any work in the national economy? Huge, huge difference. But again, if you have medical impairments, which you do if you're getting this far, and if you have tests and evaluations and doctor's visits and all of that, those military and VA records can run hundreds and hundreds and hundreds and hundreds.
Oh yeah, well that's another
thousands
question.
Of pages.
I mean, do judges? I mean, I will tell you personally. I mean, I've looked at these. I've had a case one time. My client literally physically brought in about 15 boxes of records, tens of thousands of pages,
and a lot of them are repetitive.
Oh yes, just copies of copies of copies.
Yeah,
the judges, they really read that stuff. I mean,
so here's the thing: this is a nuanced answer. The answer is yes and no. And I think this is the number one question that I get from people. Got it when I was with the agency, still get it today. Is do you actually look at my evidence? Like, is the government actually looking at what I'm sending them? And the answer is both yes and no. Yes, we look at the stuff that's important. No, we don't look at the stuff that isn't. Here's what I mean by that. I'm not trying to say your medical information is unimportant. But for example, if your doctor faxed in 15 pages of records, and that first page is the fax transmittal sheet, and the next page is just a letter saying, these are my patients. We're not looking at those, right? I'm flipping to the test results and the exam findings and comments from the doctor. And Social Security employees, both the attorneys and the judges, are very well trained. Like that's what most of the training is how to quickly and efficiently take, 1,000 pages and find the 50 pages that actually matter to turn this case one way or the other. And that's how a judge is able to spend 3 hours on average per case, even if there's hundreds of pages. They're scrolling through or they're clicking and opening all the different records, but they're not looking at the things that they don't need. I don't need to know what your vital signs were at every appointment. I'm just going to skip forward to what was your complaint? What were the exam findings? What did the doctor say? What prescriptions were you given? The things that actually tell me what your impairments are. and this is especially true with the VA records because they're so big, there's so many of them. It takes a lot of skill to go through any record, but particularly those military and VA records, to find the things that really paint the picture of what your struggles are, what your medical impairments are, how they impact your ability to work. An 80% or 100% from the VA, it's good evidence, but it has to be backed up by objective medical records, tests and objective findings and psychological reports that really tell me why you have the 100% disability rating, because that's what tells me why you can or cannot do any full-time work in the national economy, which is Social Security's standard.
Now, we know, speaking of objective evidence, we know obviously an MRI is going to be great evidence for a back problem,
right?
A cardiac function test for a heart problem. What about mental health? What's the best evidence?
It's always tough. Yeah, it's always tougher, right? Because you can't see mental health impairments or disabilities. You can sometimes observe the person, and of course, psychologists and psychiatrists, that's what they're trained on. They're trained on observing you and talking to you, and over a period of time, seeing what you're saying and how you perform on tests. Do those results seem accurate? A lot of times they'll find malingering. You were faking, because there's inconsistencies. But that's what mental health specialists do, right? They look you over a long period of time, and they look at the nuances of how you're performing. And it's different for depression or anxiety or something really, like schizophrenia that might have more obvious clinical signs of hospitalizations, or addiction impairments where maybe the person keeps ending up in the hospital. They know what they're doing. So for anyone thinking like, mental health impairments, those are the ones that people can fake. No, you can't. You can't fake an impairment.
They're looking for it.
Yeah, you can't fake even mental. Doctors don't go to school for 8 to 10 years for you to be able to fake your way through it. They know. But of course, like I said, most people aren't faking it. So it's all a matter of degree, right? You have depression, you have anxiety, you're having a hard time relating with other people, you're having a hard time focusing and concentrating. Is it enough that it prevents you from doing full-time work? Or could you potentially do some kind of simple, unskilled job for 40 hours a week? That's a gray area. And that's most cases that make it to the hearing level in Social Security. It really is a gray area that could go either way. And that's hard for the judges, and it's hard for the attorneys, because we know this person's struggling. This person says they can't work, but like we talked about earlier, they can't pay every case. There's just not enough money for that. And so that's where, our skills with looking through hundreds of pages of evidence to figure out over time, what's your presentation? Are you improving? Are you deteriorating? And to find that evidence to support that, a medical opinion one way or the other. But that's the hardest thing for the Social Security staff to do, because, and I'm sure that's probably the hardest case for you to present, right?
Yeah, absolutely.
Because like you said, it's not just here's an MRI, here's a CT scan, this person has emphysema, here's their breathing scores. Those are so, they have it, they can't work, it's objective. Right. Those mental health impairments, they really are very difficult. And it's really difficult to write an unfavorable decision. Anytime I have to write an unfavorable, it's difficult. But, if the person's 45 and they have a back impairment and they got surgery and maybe they're showing improvement, I could justify saying that person could probably return to work. It's really hard when it's a mental health impairment, because I know that person is struggling, and I could write a decision for the judge that the judge told me to deny this case, and I could write an unfavorable decision, but I kind of know that person's probably never going back to work, at least not anytime soon.
Right.
And those, don't think that if you get an unfavorable decision that it was easy, or that the government employees enjoyed it, or that they're laughing. Those decisions are really, really hard for the judges and for the staff attorneys.
Was there ever a situation where a judge might send you a form, deny this case, and you would push back and say, no, this needs to be approved?
All the time. So different judges have different personalities, and there are the whole spectrum. There were judges that I would have a 0% success rate. And it would get to the point where I don't even bother, because that judge is not going to change their mind. They don't want to hear my opinion. All the way to the other side, where there were judges who they would hold the hearing and then issue the instructions that would come to me. All I would have to do is go to them and say, I'd print out the evidence, physical pieces of paper, and I'd hand it to them and circle it and say, look, we've got this, this, and this medical opinion. I think we should pay this case. And they would just hand it back to me and go, do it. Wow. You're writing the case. You know this case better than I do, which is true. The attorneys get so much more time, 4 or 5 times the amount of time that the judge does with that case. And the really good judges would understand that and say, attorney advisor, your job is to advise me. You're the one writing the actual decision. Go ahead and follow the evidence. And if the evidence says that should be approved, go ahead and write a favorable and I will sign it. And, of course, I'm not doing that if I have to cite the actual evidence, right? Yeah, so I'm not doing that unless that's where the evidence takes me. And those are the easiest judges to write for, the ones that don't come into the hearing or the decision with a preconceived notion of what they want to do. They listen to the claimant, they give the testimony a fair review, they look at the evidence and they go, look, this is the evidence before me. My personal opinion is irrelevant. I'm going to pay this one. I'm going to deny this one. Just follow the evidence. Those are the best judges, right?
Yeah. What is let me ask you this. I sometimes will have my clients get third-party statements from former coworkers or supervisors or relatives or whatever. Does any of that have any value in your opinion?
It's really tough, because the thing is, the judges who are going to deny the case and want to deny the case, a lot of times the instructions would just say, third party, not persuasive. In other words, Spencer, go ahead and mention all the third party stuff because the law requires me to put that in the decision. No, nothing from the judge. They would just mention all the third party stuff in the E section of the record and just call it not persuasive and justify that. That's a lot of what the attorneys do in the office. The staff attorneys, they're the ones who write the actual justification. So is the judge looking at it? I mean, it's kind of like all it does is reinforce what they wanted to do anyway, I think. If it's going to be a denial, they'll say make it less persuasive, because usually it's helping the claimant, right? Like, you're not submitting third-party statements that say, nah, Bill's pretty good, he can work. Yeah. So the judges know that these are going to be in the claimant's favor, as are often the treating source opinions. And so, if I'm paying it, find those persuasive. If I'm denying it, they're not persuasive. I don't know how much the judges actually look at them. I think they kind of stick to the F section of the record.
And same question about the forms, like the adult disability report, the pain questionnaires.
Those are different.
Okay, tell me about that. Does that?
Yeah, so those are different because they're in the F section, right? They're considered medical evidence, and if it's just check boxes, if it's signed by a doctor or any medical source.
I'm talking about the claimant. The claimant fills out the.
Yeah. Okay. So we discuss those when we're writing the decision. When the attorney advisor is writing the decision, they have to talk about the. We don't use the word credibility anymore, right? That changed, but the credibility, really, right, of your client, of the person testifying. So we always start with, here's everything from the B section or the D section?
I think the D section.
They would always start with, here's all of the things the person alleged. They allege this and this and this, and they have this problem and this difficulty. And then next step, testimony. At the hearing, they testified this, this, and this, and this, and this. We were trained to write that as 3 paragraphs. Here's a paragraph of everything they put in writing. At the hearing, the claimant testified, and then everything they said at the hearing. And then go straight into I find this not persuasive because, or if it's a favorable, I find this persuasive because. And so it gets discussed in the decision. It's supposed to be anyway. As far as the value to the judge making the decision, it could help with consistency, right? If you're consistently saying like, yeah, I could do certain things, but I can't do these other things. And if those other things are specifically related to the impairment that you have, that kind of bolsters your credibility. If you're like, well, I could lift. This is what I would always wonder, why someone who's like 58 says they can't do light work if their past work was medium. And because what they should say, if they can, is like, look, I can lift 20 pounds. I just can't bend, and I can't live more than 20 pounds. Just be honest. And if they have a back impairment and it's in the lumbar spine and they've had lumbar surgery, if what they're saying is consistent with the evidence,
Right.
and that would grid them out, that's
right.
extremely persuasive, because the judge goes, I trust this person because what they're telling me is that so too is the objective testing.
Yeah.
And the donut of truth does not lie, right? The MRI machine does not lie. But if it's, I have trouble concentrating, I have trouble being around other people, I can't go to work for a full 8-hour workday, the kind of things that the judge reads all day, every day from everyone, that's going to be less helpful, right? In other words, if they're going to find that person disabled, they're doing it based on the medical records in the F section, not because the person made those statements in their application or, personal reports.
Got it. All right. So I want to zoom through a few more of these. We've got about 25 minutes left, so I want to make sure I cover as many of these as possible. And I did want to ask you this question.
And I think we're giving away another book, right?
We're going to give away another book in about 5 minutes. I thought of the question. Pre-hearing briefs. I do briefs in all my cases, almost all my cases. Persuasive, waste of time, useful?
So here's the thing. I was never a judge, so I don't know how much the judges look at them. My understanding is they're sticking in the F section before the hearing. We talked about how they don't have a lot of time before the hearing, right? My understanding from talking to them is they're not so interested in your opinion as much as they are the evidence. It can be helpful if there's lots of different impairments, or if it's a huge, 1,000-page record and they open it up an hour before the hearing and they don't know where to start. Maybe it would be helpful for you to be like, hey, by the way, here are the things that are most likely to result in a favorable decision with 6 specific page numbers. But I think, but I will say this, but the attorneys who write the decisions do look at those things. So I don't know about a pre-hearing brief. You could send it post-hearing because the attorneys don't get the case after the hearing anyway. But if there's a brief from the attorney in the E section, and absolutely at the appeals council, if you send an appeal to the appeals council, those always get looked at. It's required in our training. It's required that those get looked at the appeals council. I don't know if it's required at the hearing level, but everyone does it. And the reason is, first of all, it could help us, right? If you're showing us where page numbers are, that yes, we have to look through everything. But if you told me where all the objective testing are, the medical opinions, I get a limited amount of time to look at the case. I'm going to cheat. And if you tell me where the evidence is, I get to cheat and I get to go to those things and I can look at those first before I go through everything else. But the other thing is you're telling the story. That's really the bigger part of this. And if you're not represented and you're thinking, oh, I'll tell the story myself, I promise you don't know how. Even if you read my book and you think you know how to tell the story, you don't, because you don't know all the different nuances and aspects of the law. And those briefs, that's where the representative really earns their fee, because they're putting the complete package together. And that complete package might be a back impairment and from fibromyalgia and a breathing impairment and mental health impairments. That combined, maybe if you had 1 or 2 of these things, you could work, and you did in the past. But once the combination of things got bad enough, you had to stop working. And and it doesn't take 3 or 4 pages to put that together, right? 1 or 2 pages. The attorneys get more time than the judges, but the time is extremely limited. Don't be wordy. Get straight to the point. Cite page numbers. I can't tell you how many briefs I read over my career where, there was an MRI that said this, and in 1,000 pages, you haven't told me where to find it. Page numbers are so important because that's what I'm going to cite when I write the decisions. So just make it easy for me. So 1 or 2 page brief from the representative, putting that whole picture together, explaining like a client wants to work, he's tried to work, but he can't. And the reason he can't is this, or it's this, or it's this combination of things that limits him to sedentary. But within sedentary, he can't do the skilled work that he used to do because of this mental health impairment. And, and you pile enough impairments on top of one another, and you get to the point where the person can't do a 40-hour work week, it's really helpful for the person writing the decision, especially if I've been given instructions that tell me to write it unfavorable. And I can look at your brief and go back to the judge and say, hey, judge, did you look at this brief? Mm-hmm. Have you looked at all of these page numbers? And maybe they missed something because it was 1,000 pages. Like, hey, there's this and this and this. You sure you don't want to pay this case? They don't want to get reversed on appeal. I had a lot of circumstances where I would say that to a judge and they'd be like, yeah, let's just pay this one. Go ahead. Write it favorable.
The judges, they don't like to get, being reversed, is that something that?
It's almost like a competition between them to see who cannot get reversed. They hate it. And they grumble about, the appeals council or the federal court sent this one, because they think they're right. Yeah. Right. So if they get reversed, it's like a personal slight. They hate being reversed. But if I think we should then pay a case because the evidence supports an approval, I can go to the judge and say, judge, you're the judge, you make the decision, but just so you know, this is all of the evidence in this file. Are you sure this one's a denial? Maybe it's an approval with a later onset. Maybe once the person's depression became so right. So maybe it's something where we're not going to approve it. Oh, but maybe as of this specific date when this particular impairment got worse, what do you think about that? Yeah, sure. Go ahead and approve it as of that. And I can, at least get a somewhat partially favorable decision. That it happens all the time in every hearing office all around the country. The attorney advisor whose names you don't know, maybe you do if they call you and they talk to you about an amended onset date or something. I would have relationships with the representatives in my area because I'd call them and I'd say like, hey, we're thinking about an amended onset date. How do you feel? They would do it, and then we could make it a fully favorable, and it was out the door that afternoon.
Yeah.
So, it's knowing and having a relationship with the judges and with the staff. And again, it's not doing anything that isn't supported by the evidence. It's just taking the evidence and saying, I've got this evidence. I think we should pay it. This is the date when the evidence supports a finding of disability.
Speaking of amended onset date, here's a question, interesting question. My hearing's the day after tomorrow. I'm nervous. Okay. Physical and mental issues. I'm 54, will be 55 a month after the hearing. Would a judge ever approve the case with the amended onset date of a month after a hearing?
Well, first I want to say I have a whole section in my book about what to expect at your hearing. Okay. So whether you have a representative or not, you could get this on Amazon. Probably if your hearing's the day after tomorrow, ebook's going to be your best choice.
Okay.
But you could go get the book and listen to that section tomorrow, and that might help make you a little bit less stressed.
Right.
Because you're educated, and when you're educated and you understand what's going to happen, you feel a little bit less stressed. And that might make your testimony at the hearing come off a little more clearly, right? So that's important. But as far as the question I'm seeing, yeah, absolutely. And there's circumstances within that grid, right? Like if you have sedentary past relevant work, it's not going to help you, right? But yeah, if it's this point where 55 would be disabled and 54 is not disabled, I have written for judges that even if they didn't want to do that, they would do it. Do you want to explain the provision that allows the judge to round up to the next age?
Yeah. Oh, I'm sorry. Well, you're talking. This question. Let me, so I can address it specifically. Okay. What they're saying, what this person's saying is it possible that the judge would say, today, right, July 30th of I'm 54. The person's 54.
Right.
3 weeks from now, they'll be 55. 2 months from now. Can they issue a decision and say, I'm finding the person disabled a month after the hearing?
Well, there's two things they can do. Well, not in the future.
Okay.
You can't find the person disabled in the future, but there are two things they could do. One, they could just hold the case.
Hold it. They
could just wait
and
hold it until you're 55. But I don't know if this is still there, but when I was at the agency, there was a provision
you could round up
where if you were at the border, they could consider you to be the next age. For this exact reason. You're so close to 55. I'm just going to consider you to be a 55-year-old, even though you're not chronologically there yet. So, and it makes sense, right? If they can hold the case why can't they just issue the decision now and consider you 55?
Yeah.
I've written for judges that would do both.
Yeah. I mean, of course, there's no past due benefits, but that is.
Of course.
Okay. So we're going to give away another book here. And this one is going to have this. I feel like I'm on Jeopardy here. Let me see if I can do this here. Okay. So the question is, who is this? Who is this? What is this dog's name? Who obviously has just voted. But what is this dog's name? If you know, email me at ssdanswers123@gmail.com. And if the correct answers, you will get a link to the book.
I have so many questions, but I'm not going to ask any of them because I don't want to ruin the contest.
Yeah. There you go. But that is the next question. The person who gives the right answer here, because I talk about my dog a good bit during these.
Okay, so I'm assuming that is your dog then.
That is my dog.
All right.
That is my dog. Okay. So anyway, that's the next one. So I'll look at my answers and we'll see who's been able to answer that. Okay. Let's see. We got about 15 more minutes or so. Let's see if we can go to, okay. And I think you've kind of talked on this. How much weight does an ALJ give a medical source form, like a functional capacity form done by a specialist, like a pulmonologist or psychiatrist? I'm thinking pretty helpful, correct?
Yeah, it's really difficult for the judge if you have a breathing impairment to say that, especially if you've seen and been examined by a pulmonologist, and maybe you also have without objective testing, it's a little the opinions aren't worth as much. But if you have done one of those tests where you have to breathe into the machine and that pulmonary function test, you get objective numbers. And if you have that objective test and then a specialist like a pulmonologist saying, in my 30 years of experience in pulmonology, someone with these numbers cannot sustain a full-time work schedule on a regular and continuing basis, even for a low-paying judge, it just, an opinion like that's really hard to overcome. Mm-hmm. There are low-paying judges that pay 20% of the cases. But what I talk about in my book is you want to be in the 20%. Yeah. And that's how you get in the 20%, is what evidence you need, who you need it from, how much evidence you need. And this is a great question because this is someone who's thinking like someone who's prepared to go in front of that 20% judge and ready to be that 1 out of 5 cases that day that judge approves.
Age is a factor. How important is age as a factor? Over 50, over 55?
Well, it depends on the impairment. Yeah. Because honestly, it depends on if you have a history of like smoking or something. Mm-hmm. And I go a whole section in the book about smoking and drugs and alcohol and how the agency treats all of that. The thing is, like I said earlier, we're all aging. And as people age, look, you got people who run marathons at 67, and you have people who can't work due to their medical impairments who are in their 20s, right? It's a big country, and we got a lot of people, and it runs the whole spectrum. But sure, of course, the judge is going to look at how you were. You did work. What kind of work did you do? When did your impairments start? When did they become worse? When did you start getting treatment? Are you trying different medications? What are you doing? What other impairments do you have? How do these impairments combine? But yeah, the question is about specialists. If you've got, if it's mental health and you have a psychiatrist or a psychologist versus just your family doctor, if it's a back impairment, you're seeing an orthopedist or an orthopedic surgeon. Those opinions, even the low-paying judges look at those opinions as they should and say, I know, just based on that person's specialty, I know that person knows what they're talking about, and that's the opinion that I want. And if that person says the person standing in front of me can't work, that case has a really good shot at being approved, even by a low-paying judge.
All right. Let's talk a little bit about the book. You've written this book.
Yes.
And first of all, who is it for? And what are you going to find out when you read this book, when you go through this book?
The number one thing you're going to find out is, as we talked about earlier, all the different ways that this system is set up for you to fail. It is not a neutral system. Social Security does not have your best interests at heart. They are not trying to help you through your claim. The person on the phone might sound like they want to help you. The doctor they send you to might be really nice and friendly. They're not trying to help you. And that's what the book is going to explain to you. It's going to explain to you all the different steps in the Social Security disability process, but at each step, the way, all the traps, the things that are designed to snag you and boot you out of the system before and prevent you from getting closer and closer to having your claim approved. And I wrote the book because after 4 years at the Appeals Council and 7 years at the hearing office, we've been talking a lot today, right, about all of my experiences. And after seeing literally thousands of different cases, and you might think like, that can't be right, thousands. What did we talk about today, right? Like you get a couple hours per case over 11 years, it's thousands. Mm-hmm. After seeing thousands of cases and seeing all the different types of impairments and all the different things that people do right and things that people do wrong, when I left the agency, I thought, there's evidence. Oh, thank you. There's books out there called like How to Win Your Case. Mm-hmm. And I think those are really dishonest. Because you can't tell someone, if you follow these tips, you're going to win. That's not how the law works, right? You can say, there are things that you can do to improve your chances. And that's why the subtitle of the book is Why It's So Hard to Access Benefits and What You Can Do About It. I'm not promising you're going to win. What I'm promising you is you're going to know more about the system after you read my book than you do before you read it. You're going to have a better understanding of how things work at the state agency and the hearing level and at the Appeals Council and federal court, should you need to go that far. You're going to understand all the things that unrepresented people do and why that's such a mistake. You're going to learn all the different ways that a representative like Jonathan not can help you, but will help you give the best possible presentation to the state agency or the judge or the federal court if you get to that point. And then the last section of the book is really a bit of a pep talk. It's what you were talking about earlier, where you were saying how this isn't a handout. It's not welfare. Mm-hmm. You've paid into the system. You've paid the insurance premium. So if you need to file an insurance claim, you shouldn't feel bad about it. You shouldn't feel ashamed. It's not a problem. It's nothing wrong. It's quite literally how the law is designed and how the law is written. And I want people to understand that you're not doing anything wrong. And the opinions of other people in your community are 100% irrelevant. Anyone who talks to you about fraud, waste, or abuse, or your nosy neighbor, their opinions don't matter. Yes, it could trigger a CDR within the agency, but that's not going to get you kicked off of benefits, right? The only people whose opinions matter are the judge or the state agency decision maker, the people within the agency. And those people are making decisions based on medical evidence. Now, we've talked about how sometimes there's a gray area, right? There could be evidence that supports a pay or a deny, a favorable or an unfavorable. And that's honestly most cases. In most cases could go either way. You know that. How many cases do you take where you tell your client, I don't really know. I'm going to do my best. I'm going to present the case the best we possibly can.
Right. There are no, people say, I got a slam dunk case. Like, buddy, there are no slam dunk cases.
There are no slam dunk cases.
I mean, you get the wrong judge. I don't care what's wrong with you.
But there are things you can do to improve your chances. Mm-hmm. Like we've talked the whole time we've been talking about, making sure your evidence is well documented, getting opinions from your treating sources, making sure if you've been on leave, sick leave or annual leave, you have documentation so that you can show the judge. There's things that you can do to help improve your chances. And that's all I'm promising. I'm going to tell you what the problems are in the system, why it's hard for you to access benefits, but what you can do to try and mitigate those harms. I like to think of the process as the hurdles. We're a whole year away from the Los Angeles Olympics, but I'm going to do it anyway. You've got the hurdles. And when the starting gun goes off, you've got 10 hurdles in front of you. And, the state agency initial, then the CE, then the state agency recon, then the ALJ and the hearing and the earnings. And, each of these hurdles is there to trip you up. And you need to know why that hurdle's there, why it's trying to trip you up, how it's trying to trip you up, so that you can effectively jump over it and make it all the way to the finish line. And neither of us are promising an approval. You might still not win your case, but I have sections in the book about how to appeal, how to go to federal court. If nothing else, you can keep getting medical treatment and reapply for benefits, right? You just got to keep fighting. You got to take an active role in preparing your case. Even if you have a representative, just saying my lawyer is going to handle everything, you can't do that. You have to go to your doctors. You have to get the evidence. You have to help your representative get that evidence. You got to get opinions. You got to make sure that you work with your representative so that you can present the best possible case presentation, so that you can work towards getting the best possible outcome for your case, whatever your circumstances and whatever your evidence.
All right, we got just a few minutes left. Let me just ask you, because this is a question that comes up a lot.
Yeah.
Mistakes to avoid. You've listened to a lot of hearings, listened to a lot of claimants testify. If you had to, back of an envelope, identify the 4 or 5 things that people do that they should not do, mistakes to avoid. What are those things?
Well, the whole book is mistakes to avoid and why they're there. The number one thing, I've been saying it the whole time here, I say it throughout the book, is that you have to have a representative. The number one mistake is doing this process on your own, because there's a reason that, Jonathan, is Social Security all you do?
That's all I do at this point.
And there's people like you all across the country. That's all they do. And the reason is, this area of the law is so specific and so nuanced, and there's so many regulations.
You can't dabble. You really can't dabble.
You can't. And if you're thinking like, oh, there's too many regulations. No, those regulations are there for a reason, and every regulation does something. But you need an expert who knows the regulations and does it full time and knows how to get through the process. So the first thing is the outcome between people who have a representative and people who don't, it's night and day. You're so much more likely to have your case denied at some point along the way, and then to miss your appeal deadline, quite honestly, if you didn't have a representative who knew what they were doing. Other things are not having the right evidence or enough evidence. You can't go, oh, I'm gonna stop working, I'm gonna go apply for disability. There's a 12-month requirement. You got to have evidence over a long period of time. You can't have gaps in that evidence. You have to be seeing the right doctors. If all you're seeing is your family doctor, and you're complaining about a very specific impairment, the judge is going to want to know, why didn't you go see a specialist? Well, I stopped working and I didn't have health care. Okay. But there are things that people can do even if they've lost their health insurance. I talk about that in the book. Here's different ways you can access care so that you can continue building your medical record. Another big one, which we already talked about, is working without thinking about how that's going to impact both steps 1 and step 5 of the sequential evaluation. In other words, you're earning too much to even qualify for disability, or maybe you're not earning too much, and you thought you were staying under the SGA amount, and maybe you are, but you're doing something that the judge then turns against you and says, you know what, you're doing this work, and even though it's part-time, you're doing it, and I think you could do it full-time. So, it's every step along the way, right? It's how you apply. It's when you apply. It's not missing your DLI. It's what your onset date is. It's getting your evidence. Your evidence has to be from the right sources. You have to have the right evidence. You have to know how and when to present it. And that's what you do. That's your job. That's your career. That's what you do. That's your art form, Jonathan. And that's why you do it, because you know how to do it better than anyone. And that's why I'm telling people, get a good, knowledgeable representative, meet with them, sit down with them, talk to them, see if you think they know what they're doing. Are they asking you good, thoughtful questions? And, interview that person, because you need to find a representative. You need a good representative who's going to help you present, make the best possible case presentation. And that's a really important decision.
And by the way, I will say this, and you probably didn't see it on your end, very hard to change reps. People sometimes reach out to me and say, I'm not happy with my rep. And sometimes I'll tell them, before you do anything, just talk to this person. It's not their fault. It's taking a long time.
Yeah.
There's not much they can really.
Yeah. Well, if you sign a fee agreement with a representative and you want to change reps,
right,
you might not be able to get a new rep because that rep doesn't want to have to do a fee petition.
Correct.
And they're like, you know what? I'm out. Sorry.
Right.
Come back to me. If you lose, I want to refile, but I'm not.
Very hard to get paid if there's been another rep. And I won't at this point, fee petitions are such a pain in my, I won't do them.
It's not that you don't want to help people. It's a job. It's a career. Right. It's how you make your living, and you need to know you're going to get paid.
Yeah, absolutely.
Yeah.
So, just in terms of, we're just in a couple minutes to go.
Right.
In terms of testimony, one thing I always focus on, if the judge says, how long can you stand?
Yeah.
It's 10 minutes. It's 5 minutes. I can walk 30 feet.
Yeah.
And you need to not very much or not very far.
And you need to go over and rehearse and practice your testimony with the representative.
Yeah.
Rehearsing testimony before you go to court or an administrative hearing is not wrong, and it's not a problem. If it's the truth in the courtroom, it's also going to be the truth when you're practicing. You're allowed to do that. You're allowed to have your attorney ask you questions and to have your attorney be play the role of the judge and ask you tough questions.
Right.
When the judge asks you this, what are you going to say? Let me hear it. And your attorney's not going to tell you, no, don't say that, say this. But they might explain what you're saying is not very clear, or you're saying this and you're saying you can do this, but I don't think you can, because I've looked at the record and I don't think you should tell the judge that you can stand for 6 hours a day, because nothing in your medical records suggests that you can. And by the way, your doctor says that you can't. So I have a great example in the book of someone who doesn't know what they're doing. And I go throughout the whole hearing, and you can read this unrepresented person and what they're saying and the exact moment that they lose their case. They don't know it, but the judge is asking them questions and like you said, trying to get them to a certain point and gets them to say one specific thing, and boom, they're done. Unfavorable. And if that person had a representative, they wouldn't have said that, because their representative would have stepped in and said, that's not consistent with your medical evidence. So you shouldn't be saying that to a judge.
Yeah. No, look, one of the things that I do my pre-hearings with, a lot of times, it's folks who have been waiting a long time to be heard, and they just want to tell the judge everything. I got 45 minutes. I got maybe 25 minutes of testimony. We have to be very, very judicious in using that time. It's every second is valuable.
And as I've told you, you have a very limited amount of time before and after the hearing too. That judges other cases. Right. You have a very limited window to have their attention and to make your case.
Absolutely. All right, we're going to leave it here. This was fascinating, and we got some great comments, and I apologize to everybody I couldn't get to because we were.
Maybe I'll come back.
You absolutely going to come back. I would love to have you back, because this was, I just your passion and your enthusiasm about this and wanting to share what is really infectious, and I hope that we can get you back in the very, very near future with this.
I would hope every person having a hearing knew exactly what was going to happen, because they knew the process. Unfortunately, that's just not how it goes. So you and I are on a mission to make sure everyone has the best representation and is able to make the best presentation to the judge that they possibly can.
Absolutely. All right, everybody. And Spencer, hold on one second. But everybody, thank you very much for joining us this evening. We've been right about 2 hours here. It's really flown by, and I will look for the answers in my email, and we'll get those, I guess, the codes out very. I'll do it tomorrow, but we'll see you all next week, same time, same channel. And again, I appreciate everybody's coming to visit with us tonight.
Thank you. Thank you for having me.
Appreciate it.